This is part 2 of chapter 4 on civil liberties, and we're continuing with symbolic speech. When it comes to symbolic speech, let's talk about what is protected and what is not. Speech in the form of physical action, such as flag burning or picketing, would be considered protected symbolic speech. In the US versus O'Brien, this did prevent people from burning their draft cards. Physical speech is prohibited here because draft cards are essential to raising an army. In Tinker versus Des Moines, students were allowed to wear black armbands to school. Physical speech is protected here because wearing armbands does not disrupt school activities. In Texas versus Johnson, flag burning is protected under the First Amendment. Even though there have been efforts by Congress to enact laws to ban flag burning, it is still a protected symbolic form of speech. Looking at unprotected speech. Advertising statements only have limited First Amendment protection and are considered commercial speech. We can look at restrictions on tobacco advertising, for example. Also, unprotected speech includes libel, which are written statements, and slander, which are verbal statements, and they all fall under the category of defamation. This can be connected to concepts of lying or dishonesty. So there is a level of expectation that reporters verify their allegations. And then on top of that, however, it is very difficult to win a libel or slander case or defamation case, mainly because there needs to be proof that there was hostile intent, meaning that there was malice behind what was said or what was put out there. And so it's very difficult to prove that an individual knew that they were lying when they may have put out certain statements. Obscenity is sometimes restricted, but it's controversial because of subjectivity. So when we talk about obscenity, we might be talking about pornography, for example, and some may argue that nudity might be expressed in a way that does have some artistic or literary or even political expression. Others may see it as serving no other purpose than for sexual arousal, and therefore it should be limited. The Supreme Court also banned fighting words, which is categorized as speech that inflicts injury or results in public disorder. Now we can look at limits on freedom of assembly. We can look at individuals coming together, being able to form their own political special interest groups or political parties, or we can even look at the extension to petition or place grievances against the government to protest. But free speech can be suspended if public disorder is going to erupt. There's also a time, place, and manner in which these kinds of actions can take place. So time, place, and manner can be restricted. Also, they're intended to maintain public peace. And then also when we look at the freedom of public assembly versus the public safety and the right to be left alone, is also something to be considered when we're looking at liberties. The text mentions protests surrounding Trump's administration. And you all know that in the last 4 years, there have been quite a number of protests surrounding actions by President Trump. Now, these protests are constitutional, but there are some limitations. For example, protesters outside of rallies are certainly protected, but when those protesters enter rallies, they are often escorted out, often by police, who generally did protect them if they were physically attacked by Trump supporters, but usually felt a sense of urgency to escort them out. Again, what do you think explains the difference here in the degree of constitutional protection? Can we think of, creating a public threat in some way, that it could create public disorder, that it could also lead to a security issue? Those might be some things to think about. Next, we can move into the freedom of the press. And so the press is a place to share views on political issues. It's very important in informing the public. The internet is becoming increasingly important. We can see that government often cannot keep up with the advancements and innovations and changes that are happening with technology and the internet. 40 states have journalist confidentiality protections, but the federal government does not. And prior constraint censorship from the government is almost never allowed. What prior constraint censorship is the government trying to prevent a journalist from publishing an article or publishing a story because they may perceive it to potentially cause a future threat. So this is almost never allowed. It is certainly possible that the government could limit publication of certain stories related to public safety, national security, or obscenities. However, in the case New York Times versus the United States, the court rejected the government's attempt to censor history of the United States' involvement in Vietnam. Broadcast media is also far more controlled due to being more constrained and having a history of government regulation. The internet has not quite kept up, and the government certainly has not been able to um, regulate it to the extent that maybe it should. But we imagine that future cases will come about in which that will become more and more of a possibility. The next category of liberties we'll be looking at are freedoms of religion, privacy, and criminal due process. When looking at the First Amendment, we can look to the freedom of religion, and there are two important clauses related to religion in this amendment, the Establishment Clause and the Free Exercise Clause. So with the Establishment Clause, that bars government from establishing or supporting any one religious sect, and the Free Exercise Clause ensures individuals are not hindered in the exercise of their religion. These two clauses often conflict with one another. The Establishment Clause states that Congress shall make no law respecting an establishment of religion. This is a problem because it does little to clarify what the relationship between church and state should be. There are three possible specific interpretations: separatism, neutrality or preferential treatment standard, or accommodation. Separationism is a strict separation of church and state. The neutrality or preferential treatment standard is more flexible, permitting government to support religion provided that the support is extended to all religious groups. And then the third interpretation, accommodationism, allows the government to offer support to any or all religious groups provided that this support does not rise to the level of recognizing an official religion. What have the courts decided with regard to religion? Well, they usually reject the strictest interpretation. They've mostly allowed government to support religious schools, programs, and institutions if the support advances a secular or non-religious goal. An example would be teaching math. In the 1971 Supreme Court case, Lemon versus Kurtzman, the court struck down a state program that used cigarette taxes to reimburse parochial schools. This found that subsidizing parochial schools furthered a process of religious teaching. The court refined the Establishment Clause to include three considerations known as the Lemon Test. First question, does the state program have a secular as opposed to religious purpose? Second, is its principal effect the advancement of religion? And third, does the program create an excessive entanglement between church and state? Looking at table 4.4, we can look at religion in schools and what has been permissible by the courts or impermissible by the courts. Some actions that have been permitted would include public funding for secular purposes like busing or new computers. Impermissible activities would include requiring all students to say the Pledge of Allegiance or banning the teaching of evolution. But some public school activities that protect the Free Exercise Clause include off-campus release time religion classes, after-school student-led religion clubs, or the use of public school buildings for religious groups after hours. Take some time to look at that table and look at how religion protections have been put in place to protect the Free Exercise Clause, but at the same time how we've seen challenges between what the government sees it's permitted to do under the Establishment Clause. Religious affiliation is changing in the United States. How do you think this might affect the First Amendment? Let's take a look at Christianity, which is the most dominant religion in the US. It is also decreasing. So when we look at the year 2000 to now, we can see that Protestant populations are decreasing, going from 54% to 49%. The people who identify as Catholic has gone up a little bit from 24% to 25%. The Jewish population is decreasing from 2% to 1.5%. Islam, or people who identify as Muslim, that's the fastest growing religion in the United States, actually, 2.5%. And other faiths, 5% to 3.5%, and those that identify as not having a religion are or have gone from 14% to 21%. So we see that those that identify as being religious, that percentage is decreasing, while those that are non-religious happen to be increasing. And politically, we know that that is going to be impactful. There is a clash of science and religion in schools looking at intelligent design or creationism versus evolution. So many people who are very religious believe that intelligent design or creationism can be taught alongside evolution, and critics argue that it is an endorsement of religion by the state. Another example of where there might be conflict over the Establishment Clause and the Free Exercise Clause has to do with vaccinations. So there are mandatory vaccinations to enroll in public schools, but on the basis of religion, some people do not want to vaccinate their children, and so they opt for homeschooling instead. The federal government has placed restrictions on the Free Exercise Clause. Some court cases have limited the use of illegal drugs for religious reasons because it is illegal for all citizens. There is no exception made for religious reasons. We can see this also extended to marriage laws when we're looking at polygamy, for example. An individual can only be married to one person in the United States, and that is applicable to everyone, and it isn't targeting any specific religious group. And so these are some examples where the federal government can limit the Free Exercise Clause. The right to privacy is also an important liberty. It's the right of an individual to be left alone and to make decisions freely without the interference of others. It is tied to abortion, aid in dying, and sexual orientation. It is considered controversial because it's not explicitly mentioned anywhere in the Constitution, but can be reasonably inferred from the Fourth Amendment or the Ninth Amendment. Two major right to privacy cases include Griswold versus Connecticut, where the courts established a firm right to privacy. The issue was over whether the state of Connecticut had the power to prohibit married couples from using birth control. The court struck down the Connecticut prohibition and argued that the right to privacy was inherent within many of the constitutional guarantees. In Roe v. Wade of 1973, a woman's right to an abortion was upheld, and the right to an abortion falls within the right to privacy. The next category of liberties has to do with Amendments 4, 5, 6, and 8, ensuring criminal due process. Now, the founders wanted to ensure that there were checks on the federal government's power, especially when dealing with the creation and enforcement of criminal law. This due process is essential to guarantee that individuals can participate in the larger society and that no one person is singled out for better or for worse treatment under the law. We can first look to Amendment 4, protecting against unreasonable searches and seizures. This includes the exclusionary rule, and the criminal procedural rule states that evidence obtained illegally cannot be used in trial. So if the protections are against unreasonable searches and seizures, what constitutes reasonable? The strictest definition would mean that a warrant is always required. But there are some exceptions. In 1984, the court ruled that illegally obtained evidence could be admitted at trial if law enforcers could prove that they would have obtained the evidence legally anyway. Also, warrantless searches are allowed when there's no reasonable expectation of privacy. So the law enforcer can see something in plain view of your car window. Warrants are also obtained if a judge determines that there is evidence of probable cause of a crime. Looking at Amendments 5 and 6, these are the rights to a fair trial and the right to counsel. The Fifth Amendment bars double jeopardy, trying a person against the same crime twice. And then the Sixth Amendment establishes rights to a speedy and public trial, and the protection of these rights are based on the Supreme Court decision Miranda versus Arizona. This is the reason that individuals are read their Miranda rights when they're arrested. In Gideon versus Wainwright, the Supreme Court ruled that states must adhere to Sixth Amendment protections that give citizens the right to counsel in criminal cases. Lastly, Amendment 8 protects against cruel and unusual punishment. This is controversial because many see the death penalty as being cruel and unusual, but there is no federal policy. Those have been left up to the states.